Um, Now, one of the interesting things, of course, is you might ask the question, we have over 100,000 students, maybe more, 110,000 now, going to private schools in Ontario. You can teach in a private school without having gone to the Faculty of Education. You can teach at a private school, therefore, without being a member of the Ontario College of Teachers. I've often felt philosophically everybody that's a teacher should be a member of the College of Teachers, maybe two classifications, members and associate members. But nevertheless, if you are a teacher, if you have not gone to Teachers College, you are still in a trust relationship. I don't know how anybody could think otherwise. You're still subject to the criminal law. You still can be charged criminally. You can, and that's another reason, by the way, that documentation is so important. You can have one set of circumstances that can give rise to different court proceedings. Therefore, the documentation is important. A teacher could be charged criminally. A teacher could be sued civilly. And normally, if you sue a teacher for anything he or she has done, whether it's for negligence, duty of care, breach of duty, and usually duty of care or breach of duty is lack of supervision somehow. Teacher walks out of the room, somebody gets hurt. Teachers in the gym walks out of the gym, somebody gets hurt. A lack of supervision at recess. It can go on and on and on. But what happens is the concept of vicarious liability. So often when you sue a teacher, you also sue the principal, and of course you sue the school board. Because the principal, the duties of a principal under the Education Act, you got the duties of the teacher, 264, duties of principal, 265, and the issue is basically the principal being responsible for everything that goes on in the school. There is a section that deals with inculcating by Judeo-Christian morality. That section is probably older than me, which is somewhat difficult, but certainly it's not arguably in keeping with section 27 of the Charter of Rights and Freedoms, because it doesn't reflect multiculturalism. It was, but that's still there. It was in the days where that section would have been put in the Education Act at the very least in 1944, and it's been there since. It was certainly there in the 1970s. But again, we don't judge today by Judeo-Christian morality, because of multiculturalism. And then, of course, we talked earlier about freedom of religion, and then, of course, you've got Section 29 that specifically protects the separate school system, that teachers in particular in the separate school system can be terminated. Everybody can be terminated on the basis of just cause, but in the separate school system, you can be terminated based on denominational cause, which is equated with just cause. But that's in the separate school system. But certainly, private schools who have principals, and again over 100,000, even appreciating the fact that the Education Act is limited in its mention of private schools. I think private schools should be aware, and principals of private schools should be aware, that the courts have incorporated parts of the Education Act because into what they can do or not do in terms of suspension or expulsion of pupils, because the connection, of course, is that if you want to be accredited, then the inspectors are going to inspect those private schools. So we've got, and then I spoke briefly about the whole area of negligence, and that's another area in itself about the failure to exercise care and attention, whether it's at recess, whether it's kids coming into school at the beginning of the school day. A few things to keep in mind is the greater the risk, the greater the duty of care. In other words, the greater the risk of harm, the greater the duty of care. And also, along with that, interestingly, is arguably the younger the child, the greater the risk, the greater duty of care. A 15-year-old might be found to be contributorily negligent as to what he or she may have done. In other words, a 15-year-old running down the hall, a court might say hypothetically, you shouldn't have run down the hall. You knew what you were doing. A 5-year-old, the court might say the 5-year-old doesn't understand the nature and consequences of his or her act. So that's one area. Then you get into the whole area of consents. What can kids consent? What can parents consent to? Parents sign pieces of paper. They're consenting to. I may consent to my child playing football or my child playing hockey, which is contractual, but I'm not consenting to the coach being negligent, or I'm not consenting to the equipment being faulty, which is the law of torts. You've got negligence, and you've got to balance these two. So, and certainly one of the areas that sometimes principals fall down on is making sure every September or every year that the OSR is updated, particularly custodial parents. Do you have the same? Is it the same custodial parent? One, does the non-custodial parent have access to the child? I want to know when somebody comes into my school looking for a child, whether they have any right to see the child. They may not have any right. And parents should be advised and should be told, if you're getting a court order or if you have an agreement, let us know so we are aware of who has custody, who has access, who has the right to information. Because under the Children's Law Reform Act, Section 20, an access parent has the same right as a custodial parent to information relating to the education of their child. But they may not have access. A court can make an order. I made orders when I sat in family court that for whatever reason this person doesn't have access. So you want to update custody access. You want to update information relating to the medical history of a child. Does a child need medication? Is he or she on medication? And something else that should be insisted on, and that's if a child is on medication, is there a prescription? Arguably, if it's prescribed medication, you want a prescription. It's not good enough for me if a parent gives the principal medication without a prescription. And I want the right, and I should have the right, I being the principal, to be able to pick up a phone and call a doctor with respect to medication, because it may be the wrong medication. So, and there are cases, particularly in the United States, where the nurse refused to provide medication to a child because the nurse said that it was the wrong medication. It wasn't. The dosage was more than is normal. So that's another area. So you have to be careful about negligence, checking the plant and making, I mean, you can go on and on and on, but duty of care is very important. I mean, there was a time when negligence was one of the only areas that parents sued schools for negligence. And now, of course, it's expanded in so many areas. But again, documentation is so important. Writing down what a student says, writing down what a student tells the principal. We can go on and on and on.